For 33 years, a single microscope slide sat quietly in a police storage room, holding evidence that no one in 1972 had the technology to read. Investigators at the time had a suspect, a description, even a stained piece of paper they believed was tied to the crime, and still, the case went cold. Decades later, when that forgotten slide was finally tested, it produced only a fraction of the genetic information scientists normally rely on, 5.5 usable markers, out of the 13 a full profile requires. From that fragment, a state database of over 300,000 convicted offenders returned exactly one name. Investigators called it a certainty. The jury was told the odds of a coincidence were roughly 1 in 1 million, but another number, one that the jury never heard, put the odds far closer than that. Which figure told the truth about what the evidence actually proved? This documentary focuses on the investigation, the forensic evidence, and the legal process behind this case, not graphic detail. You're watching True Crime Files Decoded. In the early morning hours of December 22, 1972, in San Francisco's Sunset District, a 22-year-old nurse named Diana Sylvester returned home after finishing an overnight shift at the University of California, San Francisco Medical Center. She lived in an apartment near the hospital, close to Golden Gate Park. Her landlady, a woman named Helen Nigadoff, heard a disturbance coming from the unit upstairs. When she went to check, she encountered a man leaving the building, who fled before she could get a clear look at him beyond a general description. A white man of medium height, heavily built, with curly brown hair and a beard. Inside the apartment, officers found Diana Sylvester dead 3 days before Christmas. Diana Sylvester's work as a nurse placed her on rotating overnight shifts, which meant she was often coming home alone in the early morning hours, when the street outside her building was quiet. That detail mattered to investigators from the very beginning, because it meant no witnesses had seen anyone approach the building, and the only person who saw the attacker at all was her landlady, catching no more than a few seconds of a retreating figure. It was a thin foundation for an investigation, and it would stay thin for a very long time. Detectives collected physical evidence at the scene, including biological material that was preserved from the autopsy, a detail that would not become significant for another 3 decades. In 1972, forensic science had no way to convert that evidence into an identity. What investigators had instead was legwork. They interviewed neighbors, co-workers at the hospital, and anyone who had contact with Sylvester in the days before her death. That process eventually produced a strong lead. Investigators identified a man named Robert Baker as an early suspect. Baker had escaped from a mental hospital roughly 1 month before the killing. He matched the general physical description given by the landlady, and detectives learned that 2 weeks before Sylvester's death, he had committed a similar assault against another woman only 4 blocks away. Officers searching a van connected to Baker found a blood-spattered parking ticket, and the blood type was reported to match Sylvester's. By the standards of 1972 forensic science, this was about as strong a piece of physical evidence as investigators could hope for, and yet Baker was never charged. The surviving case files do not make clear exactly why prosecutors did not move forward, and Baker died in 1978, taking most of that explanation with him. Making matters worse for any future case, the blood-stained parking ticket was later lost from the evidence file altogether. With the strongest lead in the case now unprosecutable and effectively unprovable, detectives worked through a wider net of suspects. Ultimately, close to 20 individuals passed through the investigation, and crime scene technicians lifted between 26 and 28 sets of fingerprints from the apartment. None of those prints would ever be matched to a name. As months became years, the file on Diana Sylvester's death was moved to storage, one of hundreds of unsolved cases that accumulated in the San Francisco Police Department's records through the 1970s, 80s, and 90s. But one piece of that file, the autopsy slide, carrying a small sample of the attacker's biological material, remained physically intact, waiting for forensic science to catch up to it. That moment arrived roughly 3 decades later, when San Francisco received cold case funding specifically earmarked for DNA retesting of unsolved homicides. Around 2003, the Sylvester file was pulled from storage, and the decades-old slide was located and sent for testing. A criminalist with the San Francisco Police Department Crime Lab, Bonnie Cheng, conducted the analysis. What she found was both promising and frustrating. The sample was severely degraded by time, and it was also a mixed sample, containing genetic material from both the victim and her attacker. Separating the two, and reading a usable profile from what remained, is exactly the kind of technical challenge that keeps decades-old cases unsolved even after evidence is retested. Cheng was able to extract reliable data at 5.5 of the standard 13 genetic locations used in forensic DNA profiles. That number, 5.5, created an immediate problem. California's state DNA database, at the time, required a minimum of 7 usable genetic locations before a sample could even be entered into a search. According to court and investigative accounts, an analyst working the case added roughly 2.5 additional markers by extrapolating from readings that were faint and, on their own, inconclusive, bringing the profile up to the minimum threshold needed to run the search. This step would later become one of the central points of dispute in the case because it meant the profile submitted to the database was not built entirely from clean, unambiguous data. With a profile now meeting the minimum requirement, investigators searched it against California's database of convicted offender DNA, at that time containing 338,711 profiles, collected from people convicted of qualifying felony offenses across the state. This kind of search, sometimes called a cold hit, does not begin with a suspect. It begins with evidence, and it searches an entire population of previously convicted offenders to see whether any of them match. In this case, exactly one name came back: John Puckett, a man with no prior connection to the Sylvester investigation, who was in the database because of a set of decades-old convictions unrelated to this case. For the first time in over 30 years, investigators had an identity attached to the evidence from Diana Sylvester's apartment. But a single, partial profile database match is not proof, and the next phase of the investigation would need to establish whether the man the database pointed to was truly the right one, or whether the search had simply found the closest match among hundreds of thousands of people who had nothing to do with the crime. If you're finding this case as unsettling as we do, take a moment to like this video, leave a comment with your thoughts, and subscribe for more investigations like this one. Now, back to the case. By the time his name surfaced in 2004, John Puckett was a retired carpet installer living in a trailer park outside Stockton, California. He was not a stranger to the criminal justice system. In 1977, he had been convicted of 2 rapes and a separate sexual assault in the Bay Area, and it was that conviction that had placed his DNA into the state's offender database years before investigators ever searched it in connection with Sylvester's case. He had served time for those offenses and had been registered as a sex offender since the mid-1980s. Before approaching Puckett directly, investigators moved carefully. A cold hit from a database search identifies a candidate, but any competent investigation treats that candidate as a lead to confirm, not a conclusion to act on. In October of 2005, San Francisco Police Department Homicide Inspector Joseph Toomey traveled to the Stockton trailer park where Puckett lived with his wife. Toomey was part of a 2-person cold case unit within the department, working alongside Inspector Holly Pera, a unit that would later go on to help connect serial offender Richard Ramirez to an unrelated 1984 killing in San Francisco. At the time of this first interview, Puckett was recovering from heart bypass surgery. He denied ever knowing Diana Sylvester. A cold hit alone could not be used to charge him. Investigators needed a fresh, independently collected sample that could be directly and reliably compared to the crime scene evidence, free of any question about how the original profile had been assembled. According to investigative reporting on the case, Puckett cooperated with this step, providing a new sample, and he even gave detectives advance notice when he and his wife planned to relocate to Oklahoma. When the newly collected sample was compared against the profile from the 1972 evidence, it matched. On the strength of that confirmation, John Puckett was arrested in 2006 and charged with first-degree murder, more than 3 decades after Diana Sylvester's death. The charge set up what would become one of the more closely watched DNA cases in California legal history, not because there was any dispute that police had found a genuine match, but because of a question that goes to the heart of how forensic statistics should be explained to a jury. What does a 1 in a million DNA match actually mean when that match was found by searching hundreds of thousands of people rather than by matching evidence against a single known suspect. The trial took place in San Francisco Superior Court, presided over by Judge Jerome Benson. The prosecution was led by Assistant District Attorney David Marin. Puckett was represented by two public defenders, Quickshuan Malouf and Bicca Barlow. Barlow notably held an advanced degree in genetics and molecular biology, giving the defense an unusually strong technical footing to challenge the state's forensic evidence on its own terms. At trial, prosecution witnesses testified that the random match probability for the partial DNA profile recovered from the 1972 evidence was 1 in 1.1 million, meaning that, among unrelated members of the public, only about one person in that many would be expected to share the same set of genetic markers by chance. One expert witness went further, offering a likelihood ratio figure suggesting the odds were closer to 1 in 152 billion. To the jury, these numbers were framed as powerful, near-conclusive evidence. The defense argued that this framing left out something essential. Puckett had not been identified because investigators suspected him and then tested his DNA to confirm it. He had been identified by searching an entire database of 338,711 people, and when a search casts that wide a net, statisticians distinguish between two different numbers. The first is the random match probability, the odds that any one unrelated person, picked at random, would share the profile. The second is the database match probability, the odds that, somewhere within a search of that many people, at least one coincidental match would turn up, purely by chance. Multiplying the rarity of the profile by the size of the database being searched produces a very different figure. In this case, defense experts argued it worked out to roughly 1 in 3. Judge Benson ruled that this second figure, the one the defense wanted to present, was essentially irrelevant and excluded it from trial. He also declined to tell the jury that Puckett had been identified through a database search at all, rather than through any direct suspicion connecting him to the case from the start. The jury also never heard about Robert Baker, the 1970s-era suspect with the matching blood type evidence and the now-lost parking ticket. The judge excluded that evidence as well, meaning the 12 people deciding Puckett's fate evaluated the DNA statistics without knowing that another named individual had once been strongly suspected of the same crime. What the jury did hear, over defense objection, was testimony from 3 women who had been victims of Puckett's 1977 crimes. Each described how Puckett had posed as a police officer, forced them into a vehicle, and assaulted them at knife point. California law permits this kind of pattern testimony in sexual offense cases specifically, but defense attorney Malouf would later say it gave jurors ample reason to view Puckett unfavorably, regardless of how they weighed the DNA evidence on its own. In closing arguments, prosecutor David Marin worked to make the 1 in 1.1 million figure meaningful to a jury that might struggle to grasp such a large number in the abstract. He pointed out that California's population in 1972 was roughly 18 million people, about half of them male, and argued that when the rarity of the genetic profile was applied against that population, only about 8 or 9 people living in the entire state at the time could have matched it, and Puckett, he told jurors, was one of them. He argued the DNA evidence pointed directly at the defendant, telling the jury it demonstrated his guilt. After deliberating for roughly 48 hours, the jury convicted John Puckett of first-degree murder on February 21, 2008. He was sentenced to life in prison. Because the crime had occurred in 1972, decades before California adopted its modern determinate sentencing structure, the applicable life sentence under the law in effect at the time of the offense carried the possibility of parole after a minimum of 7 years served. One detail from jury deliberations later became a notable footnote in coverage of the case. During deliberations, jurors sent Judge Benson a written question asking exactly how Puckett had first been identified as a person of interest. The judge declined to answer it. After the trial concluded, several jurors spoke to reporters, and one juror, Joe DeLuca, was asked directly whether learning about the 1 in 3 database match probability, the figure the defense had wanted to introduce, and that the jury never heard, would have changed how he viewed the case. He said that it would have changed a great deal. Puckett's conviction became a significant point of reference in the broader legal and scientific conversation about how cold-hit DNA evidence should be presented in court. Just months after his trial concluded, the California Supreme Court issued its ruling in a separate case, People v. Nelson, addressing very similar questions about whether rarity statistics remain admissible when a suspect has been identified through a database search rather than direct suspicion. The court held that they do, reasoning that the database itself is not on trial, only the individual defendant is. That ruling reinforced the framework under which Puckett had already been convicted, even though it did not arise from his own case. Puckett's case is also frequently discussed alongside a related but legally distinct California precedent, the use of what is known as a John Doe DNA arrest warrant, a legal tool that allows prosecutors to file charges against an unidentified individual, described only by their genetic profile, before the statute of limitations on a crime expires. That tool became central to a separate California case, People v. Robinson, arising out of a 1994 sexual assault in Sacramento County. In that case, a deputy district attorney filed charges against an unknown John Doe, identified only by a 13-marker DNA profile, just days before the 6-year statute of limitations would have expired. A later cold hit identified the man responsible, and the California Supreme Court ultimately upheld the practice in a narrow decision, ruling that a DNA profile satisfies the constitutional requirement that an arrest warrant describe its subject with sufficient particularity. It's worth noting that this tool was never actually necessary in Puckett's own case. Under California law, murder carries no statute of limitations at all, so no such warrant was ever required to bring the charge against him, no matter how many years had passed since Diana Sylvester's death. John Puckett appealed his conviction, and the appeal was still pending, unresolved, when he died on July 21, 2010. The California Court of Appeal never issued a ruling on the merits of his case. His conviction stands as it was returned by the jury in February of 2008, guilty of first-degree murder, on the strength of a partial genetic profile recovered from a piece of evidence that had waited, undisturbed, for more than 30 years before science finally caught up to it. The debate his case sparked, however, did not end with him. The question that split his jury, and that still divides forensic statisticians today, whether a 1 in a million match found by searching hundreds of thousands of people should be described to a jury the same way as a 1 in a million match found by testing one known suspect, remains an active and unresolved issue in how DNA cold hits are presented in courtrooms across the country.